Good morning, everyone. My name is Matthew Atea, and I am the Director of Guided Personal Supports and Community Resources here at Northeast ARC. We have a great session planned today. We have a presentation led by Abigail Poole from Planned Special Needs Trust, followed by a guided Q&A facilitated by our North Shore Community Resource Specialist, Carrie Neenan. Before we get started, I'd like to share a few announcements. There we go. So for those who are joining for the first time, the Northeast Transition Collaborative Network hosts monthly virtual sessions focused on adult services, transition planning, employment, community opportunities, and resources for transition-aged youth and young adults with disabilities. In addition to our webinars, we develop resource guides on transition-related topics and offer quarterly in-person professional development opportunities for educators focused on person-centered transition practices. December 2025, the Northeast Transition Collaborative Network became a DESE approved professional development provider. For educators seeking professional development points for today's session, you must attend the webinar in its entirety. You must complete our feedback survey that will be included in our follow-up email, and complete the post-session knowledge assessment that we'll be sending out in that follow-up email as well. And please note that PDPs are awarded once participants complete a minimum of 10 hours of approved professional development within the topic area of special education transition. If you do have any questions regarding PDPs or the certification process, please contact us at Community Resource Center at ne-arc.org. Following today's session, you will receive an email containing today's presentation slides, a resource guide on our financial planning series, and our event guide. And if you'd like to access our resource guide now, you're welcome to scan the QR code. Leave that up for a minute or two if you have your mobile device. And as always, your feedback is really important to us. It helps us improve our network and provide sessions that you are looking for regarding person-centered transition planning. So please feel free to fill out our feedback survey. We'd love to get your feedback. And I'm just going to go over a couple of our upcoming sessions as well. In August, on August 11th, we're doing a session on healthy relationships and boundaries. This will be presented by the Commission for the Protection of Persons with Disabilities, formerly known as the Disabled Persons Protection Commission. This session will focus on how participants will deepen their understanding of healthy relationships and boundaries, including recognizing signs of unsafe situations, and apply strategies to promote safety, consent, and self-advocacy among youth and young adults with disabilities. We'll be sending out a registration link in our follow-up email, but you're also welcome to register now if you scan the QR code here. In September, we're going to be inviting the Department of Developmental Services to do a presentation on navigating transition together, exploring DDS adult services. We'll have more information in the next week or two regarding this session. So stay tuned on that one. And the Northeast Transition Collaborative Network is partnering with the ARC of Massachusetts for their biannual transition conference. Transition Journeys Conference in 2026. Tools for today, hope for tomorrow. Registration is open for that. That one is a paid event. There are some early registration prices as well, prices for educators and support as needed. That will be on Saturday, October 24th, and that is at the Renaissance Framingham Hotel. We'll provide more information within our network as that starts coming together. Not sure why the feedback survey popped up again. Well, from there, we will turn it over to Abigail Poole from Planned Special Needs Trusts. Abigail, thank you so much for joining us today. I'll turn it over to you.
Great. Thank you very much, Matthew.
Thank you.
I am going to, let's see. share my screen, so bear with me, make sure we do this right here. And you can let me know if it pops up correctly. Can you all see it okay?
Yes.
Yes, fantastic. Okay. So, again, as Matthew said, my name is Abigail Poole. I am the in-house counsel for Plan of Massachusetts and Rhode Island. And here's a little bit about me. And so I kind of expect the presentation to take about 50 minutes or so. And we will talk about special needs trusts and ABLE accounts. I am by no means an expert or authority on ABLE accounts, but I do have some resources and I can give you some basic information to know about them. And really the bottom line or the takeaway is that special needs trusts and ABLE accounts can work together. They do slightly different things, and you can have both at the same time. So that is, I would say, the biggest mind that this is really going to be a high level presentation of special needs trusts and ABLE accounts, and that they're typically encourage that you utilize the services of an experienced elder law or special needs or estate planning attorney. And they will really be the best person to advise you on your very specific situation. Everybody's situation is a little bit different. And so they will ask you questions to be able to best provide you with advice. And we oftentimes work collaboratively with estate planning, elder law, and special needs attorneys. All right. So I also wanted to note, again, I think Matthew covered this, but it is being recorded. So there may be thoughtful about some of the things that you may mention if you are concerned about what you say being recorded or being on a public forum when we get to our questions section. All right. So that kind of takes care of the general breakdown there of what to expect with regards to the presentation. I want to tell you a little bit more about PLAN so that you have an idea of kind of where we're coming from. So PLAN stands for Plan Lifetime Assistance Network of Massachusetts and Rhode Island. And we are a nonprofit organization that provides professional trustee services for special needs trusts. We have been serving people with all types of disabilities, whether that's due to illness or age or injury, for over 50 years. And we do that by helping them preserve their assets in order to protect their public benefits and also to maintain quality of life. Currently, we have around 874 beneficiaries, and we are managing assets of around $95 million. The lens by which we are completing or doing our trustee services, providing our trustee services, is that we really are trying to make sure that we are retaining public benefits while supporting the beneficiary's quality of life. So that's how we're viewing a lot of our services and the administration of trust for the benefit of a beneficiary. Every beneficiary, and I'll talk about terminology in a second, has a dedicated service coordinator who's a licensed social worker. And that person is meeting with the beneficiary and their support team to determine the beneficiary's needs and also wants in connection with helping them maintain quality of life. And working as a team with the trust officer to make sure that the trust funds are being utilized for the benefit of that beneficiary appropriately while maintaining their public benefits or their eligibility for public benefits. So just to give you a quick rundown of what we're going to talk about today, the objectives are to understand the legal foundation and purposes of a special needs trust, the types of special needs trusts, we're going to spend a fair bit of time there, trustee responsibilities and considerations, what the overall process is to establish a trusted plan, an overview of the ABLE accounts, and then also a comparison of special needs trust and ABLE accounts. Like I mentioned at the top of the presentation, they are great companions for each other and work together very well. They do slightly different things, and that's why they work together really well. So let's go through a little bit of terminology. I find that that's helpful to do, again, at the top of a presentation, because you'll hear me use this language throughout the rest of the presentation. So what is a trust? A trust is essentially an entity that is created by a legal document that you sign. It is oftentimes called a trust document or a trust instrument. And once you sign this piece of paper, this trust, then you have created the trust. The trust, this entity, can either have money or assets put into it once it's been created, so immediately, or the trust can be created and funds can be put into the trust, or assets can be put into the trust at a later time. Within our world, we call that a future funded trust. So if you, for example, are a parent with a child with disabilities and you are concerned that when you pass away, providing the inheritance that you want to leave for your child with disabilities directly to that child would endanger their public benefits, a special needs trust could be created now for your child, but it could be funded at the time of your passing with the inheritance. That could be 20 years later. So that's what I mean by a trust being created and then a trust being funded, and they can happen at two different times, or it can happen essentially concurrently. So we'll go into that a little bit more. A trustee, that basically is a synonym for manager or administrator of the trust, a grantor or donor. So that's the person who creates the trust within with regards to this presentation. That would be, regarding that example I just gave, the parent, for example. Let's say mom creates a trust to benefit, we'll go with Rose, for her lifetime after mom passes away. Mom is the grantor, the creator of that trust for Rose's benefit. And Rose, the individual with disabilities, the child with disabilities, is the person who is the beneficiary of the funds in that trust. Makes sense? Again, this is for, again, the purposes of this presentation. If you go into the realm of estate planning a little bit more, sometimes there's different terminology. So I just want to be clear that this is the world we're in currently and how I've defined things here. If we're talking about public or government benefits, funds that a beneficiary may be eligible to receive or may already be receiving from the federal or state government. For example, supplemental security income, Social Security disability insurance, housing vouchers, Section 8, Medicaid, and potentially SNAP. You will hear me use the term special needs trust and supplemental needs trust. Those terms, again, for the purposes of this presentation, I'm using that interchangeably. There is some conversation or differences of opinion out there that say special needs trust means this and a supplemental needs trust means that. So do not be surprised if you encounter somebody who does view those as two different documents or instruments. Again, for the terms of this presentation, you'll hear me use it interchangeably. I sometimes like to use supplemental needs trust because it reminds me that this type of trust, the funds in it, are there to supplement any public or government benefits that the beneficiary of the trust may be receiving. Okay, where did special needs trust come from? How is this something that we can utilize? This started with the OBRA 93 law that passed in 1993, and it allows for the establishment of special needs trusts. What it's doing is it allows an individual with disabilities, the beneficiary, to benefit from the funds in the special needs trust without losing their eligibility for government benefits, so long as they're utilizing the funds in a way that's appropriate pursuant to the guidelines that are in place in connection with the public benefits. So that includes thinking about how much assets the beneficiary may have, how much in assets they may have, and then also what kind of income they have, and making sure that the funds in the trust will not endanger those benefits that they also have. And so it's an ongoing consideration. It's not just putting the money in the trust. Now they're below the asset limit and now everything's going to be fine. We want to be careful about how the funds are distributed, or what we call disbursed, from the special needs trust, because there's certain rules in place that say if you disperse them in one way and the person is on particular public benefits, that could impact their public benefits. So it's being really thoughtful about how the funds come into the trust and how the funds are also distributed or disbursed during the beneficiary's lifetime from the trust in connection with the public benefits they may be receiving or could be eligible to receive. And so where are these guidelines that we're typically looking at? There's several. And depends on the benefits that the beneficiary is receiving, right? The public or government benefits the beneficiary is receiving. But one place that is a significant source of guidance, not just for us, but because of this, is the POMS, and it's the Program Operations Manual System of the Social Security Administration. And this is actually looked at by caseworkers, administrative law judges, and others to determine if a disbursement or the assets of a particular beneficiary are permissible or not, or if they will potentially impact benefits. So we look at those guidelines too, because if they're looking at them, interpreting them, we should be as well, to make sure we're doing things appropriately. So, and we are actually recognized in the POMS manual. You will see that in the guidelines there. And we have been for a while. All right. So I already talked a little bit about what a special needs trust is. We talked about how it's created, right? You have a document that you create, and it's a legal document, and you sign it, and that creates the trust. That establishes it. And then you can put assets or funds into the trust, either immediately or later at some point in the future. And typically, with this type of trust, assets that are held by the trust are not considered a resource when qualifying for particular types of government benefits, where a person is restricted with regards to those resources. So a good example of that is supplemental security income and Medicaid. For example, with Medicaid, let's say you are an individual who is applying for Medicaid benefits to pay for your care in a long-term care skilled nursing facility. You in Massachusetts can only have essentially $2,000 and your primary residence. So that's what I mean by resources, and if you and the restrictions for being eligible for these types of public benefits. Essentially, what the Supplemental Needs Trust does is that it is supplementing, not replacing, those public or government benefits. It allows the beneficiary to keep the benefits, but still utilize the funds or assets that are held in the Special Needs Trust throughout their lifetime to cover things that the public or government benefits do not cover. And that could be other needs. It could also be other wants, right? That could be for quality of life. For example, we've had situations where individuals would like to go on a trip, go on vacation, and they're on public benefits, but at the same time, they have a special needs trust. Depending on the situation, and it's reviewed on a case-by-case basis, the funds in the trust may be used to pay not only for the beneficiary to go, but potentially a companion to go with that person should they require that assistance. And keep in mind that one of the reasons that we utilize POMS in particular is that oftentimes supplemental security income is kind of the foundation. It opens the doors and it's the most restrictive in many ways for how funds may be utilized and eligibility in connection with that for public benefit, that particular type of public benefit. So that's one of the reasons that we are utilizing POMS as well in connection with determining disbursements being made from the special needs trust. So very quickly, a special needs trust allows for planning for the future. It preserves public benefits while supplementing needs and maintaining quality of life for the beneficiary. And again, it covers those costs not covered by benefits. So let's spend a little bit more time talking about types of trusts. And I just want to be really thoughtful about time here. Okay. So there are essentially three types of special needs trusts. You have a third-party standalone trust, a special needs trust, a first-party D4A special needs trust, and then a special needs pooled trust. And interestingly, you can either have that as a first party or a third party. So let's dive into those different types of trusts. So the first type of trust is a third-party standalone special needs trust. You may also hear it referred to as a standalone third-party special needs trust. Same thing. It is a legal document that is actually prepared by an attorney and for one person. It has very tailored and individualized terms based on the beneficiary situation. It's typically a more flexible arrangement because the funding is from a third party, thus the term third party special needs trust. So that example I used earlier, where a parent decides that they want to create a trust so that the inheritance they want for their child with disabilities goes to the trust instead of going directly to that child and potentially endangering any public benefits they're getting. That is a perfect example of a third-party special needs trust. And so a third-party trust, that's a good tool. You can do it as a standalone trust, again, utilizing the services of a special needs attorney, an estate planning attorney, elder law attorney, dependent on your particular situation. And there's not a lot of POMs or guidelines around third-party special needs trusts, which means there's more flexibility oftentimes with what kind of disbursements that can be made from the trust. On top of that, I'm going to talk about what's called a Medicaid payback provision. So a third-party trust does not have a Medicaid payback provision. What is that? A Medicaid payback provision is a specific clause or provision that says when the beneficiary in the trust passes away, then any funds remaining in the trust first must pay back Medicaid for any of the expenses Medicaid paid for during the beneficiary's lifetime, up to an equal. So if there are $100,000 left in a trust, we're going to call it a first party trust, and so there's $100,000 left. Let's say Medicaid says there's a $50,000 of expenses that were paid out to assist the beneficiary over their lifetime until they passed away. Then the trustee has the responsibility to pay that $50,000 to Medicaid, and that takes care of that Medicaid payback. The remaining $50,000 can be distributed according to the terms of the trust. So that means if there are amounts remaining above or beyond the funds that have to be paid out to Medicaid, they could potentially go to what we call the remainder men, the people that are named to receive those remaining trust funds. Sometimes there's funds left, oftentimes there's not. So if the entire trust is utilized, the remaining trust funds are utilized to pay off Medicaid, then there would not be any sort of funds to go to the remainder men in that kind of situation. And you don't really know. You don't really know what's going to happen in the future, right? So it's really dependent upon when the beneficiary passes and how much is remaining in the trust. So again, a third-party standalone trust, there is no Medicaid payback clause. The trustee for a third-party standalone special needs trust can be either a professional or a non-professional. So a non-professional trustee would be someone who is a family member or a friend. We've seen situations, for example, where standalone trusts have actually been transferred to us to serve as trustee instead, where there have been siblings named as trustee for another sibling beneficiary. And I'll talk about that a little bit more in another slide about the pros and cons of doing something like that. So a professional trustee is somebody like Plan. So it can be a nonprofit organization. It can be a financial institution. There's several banks out there that serve as trustees. It can be an attorney. It can be an accountant. That's what we mean by a professional trustee. So that's a little bit about third-party standalone trusts. Let's talk about first-party D4A special needs trusts. So this is, again, a document that is drafted by an attorney for one person with individualized terms. The funds for a D4A trust, a first-party D4A trust, instead of coming from a third party, are actually coming from a beneficiary. So a really good example of that is, let's say there is a person who is in a horrible accident and they get a personal injury settlement. And they're on receiving public benefits, instead of receiving that personal injury settlement and having those funds then potentially jeopardize the public benefits they're receiving, they could instead have that personal injury settlement go into a first-party D4A trust. One of the key things to note about that is a standalone, this first-party D4A trust can only be done when somebody, the individual with disabilities who's creating it, is age 64 or younger. So what are the two differences then, or the difference between the third party and the first party? It's who's creating it and funding it, right? With a third party, you've got a third party creating the trust for the benefit of the beneficiary. For the first party trust, you have the beneficiary creating the trust for their own benefit during their lifetime. Keep in mind that a first party trust has a Medicaid payback provision, right? And there is more requirements with regards to how those disbursements are made from that trust, depending on the benefits the person is receiving. So if we're thinking about another difference here, there's the Medicaid payback provision for the first party trust, and there's no Medicaid payback provision for the third party special needs trust. So one way I like to remember that is if Medicaid gets paid back first, it's a first party trust, or vice versa. All right, so what's the third type of trust? And the third type of trust is a pool trust. As I mentioned previously, a pool trust can actually be either first party or third party. So I'm going to give you some examples of these in just a second to hopefully help clarify what type of trust may be useful. So a pool trust is different from a standalone trust. It's different from a third-party standalone special needs trust, and it's different from a first-party D4A special needs trust because it has its own master trust instrument. So this is a document that has already been created, and essentially a beneficiary or their representative, their legal representative, signs a document that says, I want to join this master trust instrument that is already in place. A pool trust has to be managed by a nonprofit organization. That is required under the federal law. and state law, in fact. It's typically a really good option for being cost effective when there's a small estate or inheritance. Why is it called a pool trust, right? So it's called a pool trust because everybody's funds are essentially pooled for investment purposes only. What that means, and that makes it more cost effective. That's how it is more cost effective. However, every beneficiary retains their own sub account. So their money is not utilized for somebody else. It's only utilized for that beneficiary. However, the funds are pooled for those investment purposes. So let's go through, and I think those are okay. So the only other thing to kind of highlight, again, because you can have a third party pooled trust or a first party special needs pooled trust, keep in mind some of the differences we talked about previously apply here. So if you have a first party special needs pooled trust, then the beneficiary is the person creating that trust and benefiting from the assets in that trust during their lifetime. And there's a Medicaid payback clause, right? First party trust means Medicaid gets paid back first. If you have a third party special needs pool trust, again, that is created by somebody else for the benefit of a beneficiary during their lifetime, and there is no Medicaid payback clause there. All right, so let's talk a little bit about
what's up, Momo? What's up? How you guys been doing? All right.
Sorry. So let's talk a little bit about examples. I hope will make this clear. So let's talk about Jane Doe. So I'm mentioning this particular scenario because you or other family members or friends may be in this kind of situation, which is maybe you are looking at taking care of your own children, and maybe you have aging parents who are contemplating utilizing Medicaid benefits to pay for a skilled nursing facility. So while that's not the focus of today's presentation, I think it's really helpful to talk about because it might fit a scenario for either you or another family member or friend, and for you to share that information with them. So Jane Doe is 80 years old and she has $15,000. She is looking at moving from home to a skilled nursing facility because her health has declined, and she wants to apply for Medicaid benefits to cover her expenses in that skilled nursing facility. So as I mentioned earlier, because Jane Doe is an individual, she can only have $2,000 and a primary residence in order to and still be able to receive Medicaid benefits. But as you can see, she has more than $2,000 in assets. She's got $15,000. So what can Jane Doe do? She can spend down some of those funds on what are called permissible expenses, and she can take any excess over that $2,000 and put it into a first party special needs pool trust. And then what that means is that those funds are available. She qualifies immediately for Medicaid from a financial perspective, right? Now she's meeting those the financial eligibility requirements, and she's now got $13,000 in a special needs pool trust, in a first party special needs pool trust, that she can tap into to pay for other things that are not covered by the Medicaid benefits. Another good example of what I call that first party D4A trust is John Smith. So John has a personal injury settlement of $800,000. He's 32 years old, right? He has to be under age 64. And because he's on public benefits and he wants to maintain those public benefits, he can put that $800,000 into the first party D4A trust and continue to receive his public benefits. At the same time, he's got those funds in that first party D4A trust that he can utilize over his lifetime. Again, if he has any funds remaining in the trust after his passing, Medicaid would be paid back first for the amount that they covered during his lifetime. All right, So Mary Jones is a really good example, particularly for our parents out there. So Mary Jones is 54 and she is inheriting $50,000. Her mom from her mom, who just recently passed. Before mom passed, she created a third-party special needs pooled trust for Mary, and Mary's on public benefits. So instead of having the funds go directly to Mary and potentially endangering her public benefits, they go to the third-party special needs pool trust that mom created for Mary. So now Mary gets to keep her public benefits. We're not concerned about them being in jeopardy. And she's got that $50,000 inheritance from mom's estate that she can now utilize to supplement the public benefits she's getting. So by doing that in advance, mom was able to assist Mary with maintaining her public benefits. Let's say mom did not get a chance to do that advanced planning. She didn't do a third party special needs pool trust. Mary still has the option available, right? So if mom says in her last will and testament, when I pass away, this $50,000 goes directly to Mary. What Mary can do before she receives those funds is create a first-party special needs pool trust in her own name. And then the funds can transfer to the trust at that time. And again, that is reducing the possibility of any sort of endangerment to her public benefits. How are we doing on time? We're okay. So that is where, but what's the difference here, right? When Mary passes away, if there's any funds remaining in that first party special needs pool trust that she created, those funds would first have to pay back Medicaid. If mom did advanced planning and did that third party special needs pool trust, the funds remaining, if there are any, would go to the remainder men, the people that mom says she wants the money to go to when Mary passes. Okay. So very quickly, here's a few examples of how you can fund a special needs trust. Third party, again, inheritances, right? If that's the sale, the proceeds from the sale of a real estate, investment accounts, bank accounts. So the assets from an estate, the inheritance, for example. Life insurance proceeds as well can fund a trust, a third party special needs trust. First party special needs trusts, again, settlements like personal injury settlements, or like in Mary's situation, if mom did not do planning in advance, an unexpected inheritance. Okay, a few things for you to consider when you're establishing a special needs trust. What type of trust best suits your situation? Hopefully, with what we've talked about already, you're starting to think about what kind of trust might be a really good fit for your particular situation. What type of trustee do you prefer? Do you want to be a professional, or are you comfortable with a non-professional? How would you want the funds to be managed? Would you be comfortable with a non-professional trustee being responsible for managing the investments, the assets that, and dealing with the investment aspect of the funds in the trust? Or would you prefer that there's a professional who's really doing that kind of investment management work? So some of a trustee's responsibilities. So they have a fiduciary obligation. A trustee has what's called a fiduciary obligation or duty to administer trust funds properly. So that includes doing that investment management portion that I just discussed. It includes making sure that they are overseeing the income and expenses and disbursements regularly from the trust for the benefit of the beneficiary. They also have to annually prepare taxes. They have to report because it's a special needs trust, and depending on the beneficiaries' types of public benefits, they may need to report to certain agencies about the existence of the trust. They also need to be able to follow those public benefit guidelines like we were talking about earlier. So not to understand them and then apply them to the beneficiary's specific situation and the disbursements that are being made on behalf of the beneficiary. Also to keep in mind, special needs trusts, the funds in the trust are really meant to be for the sole benefit of the beneficiary during their lifetime. So keeping that in mind as well. And then lastly, really maintaining contact and open communication with the beneficiary and to the extent it applies, other members of the support team for the beneficiary. Okay, so again, continuing to think about those trust administrations, that trust administration, consider, is the trustee that you're thinking about naming, are they knowledgeable? Are they skilled regarding those regulations we talked about? Will they be able to serve for the life of the trust? What are their health issues? What is their age? And is it possible? Is there somebody who's named as a backup if that person may become ill or needs to decline to serve as trustee for some other personal reason? So what are some of the benefits of a professional versus a non-professional trustee? So plan is a good example of this. This is what we do. So there's timely processing of disbursements and doing the accounting and the tax reporting. Also making sure that we're appropriately communicating with Medicaid and other agencies, and making sure that the services and disbursements are there to enhance the quality of life for the beneficiary and preserving family relationships. So this is something that I want to spend a little bit of time on. Oftentimes we are seeing people come to us where a family member has named another family member to serve as trustee of a standalone trust for a beneficiary. And because there's this potentially tension now, let's say we have one sibling serving as trustee for another sibling who's the beneficiary. When the beneficiary, who's the sibling who's the trustee, has to say no to the sibling who is a beneficiary about making a disbursement from a trust because it may endanger their public benefits, or we've had situations where there might be a beneficiary who is being coerced or unduly influenced by other people in their life to request funds from the trust. Now we've created a situation where there may be conflict between family members, between siblings, because of this, and that is going to cause disharmony. So that's something that's really important, is and it may be important for some, may not for others, is contemplating, is it a priority to preserve those family relationships and preserve that harmony, and to what extent is that a goal or priority for you? Typically, there's also, when you have a professional trustee, the ability to have ongoing reduced costs when there's a pool trust in play. Okay, so very quickly about the application, and then I want to make sure that there is time for ABLE here. So the general process, just so you know, is you complete an application that can be done online. Once the trust is created, after we receive the application, and the trust is then funded. So those two things have to happen. The trust is created and the trust is funded, which I talked about earlier, could be several years later. At that time, a licensed social worker, which we call service coordinator, is going to reach out and work with the beneficiary and their support team to determine what's called a spending plan. And that is developed by looking at a variety of different factors and in conversation with the beneficiary and their support team. You're looking at the person's age. You're looking at the benefits they're currently receiving or that they might be eligible for. You're looking at their life expectancy, their income. What are some of their other needs? What are some of their other wants? Do they want to go on a vacation and do they need a companion to go with them? Do they need to purchase newer furniture because they have, let's say, a mattress that is really old and it's at a point where it needs to be replaced? So there's a lot of things that go into that conversation and development of a spending plan, which is done with the service coordinator. And it is not stagnant. It is something that also changes. And then what we do is we have a trust officer that then is reviewing those requests for disbursements from the trust to make sure that they are not going to endanger somebody's public benefits and that they are going to really be the best thing that can be done for the beneficiary at the time. Again, it's reviewed on a case by case or disbursement by disbursement basis at the time it's provided. The funds are invested in an investment strategy. That investment strategy and those are reviewed. And if somebody's investment strategy needs to change because there's been an increase or a decrease in the amount of funds that are in the trust, then that is done on a regular basis. And again, plan doesn't have any minimums for pooled trusts, but we do typically recommend about $10,000 at minimum. Again, there's not a minimum, but we do recommend $10,000 because that gives us funds to then invest and start generating income and potentially build the funds in that trust. Okay. The disbursements are reviewed, and there's usually a response from us within 7 to 10 business days. Again, we prepare the tax forms on an annual basis that are necessary, and then forward that on to the beneficiary or legal representative for them to then report on the person's personal income tax returns, if that's applicable. The funds are managed professionally. And again, with a pool trust, we can work with any age or disability or amount. All right, we talked a little bit about the service coordinator. Again, they are licensed social workers, which is something that's unique to plan. They're typically collaborating with the beneficiary and their support team, again, with authorization, developing that spending plan, which I touched upon, and it's individualized, really looking at what are some other community support or engagement that might be available, other resources for that beneficiary. So it's very much tailored to the needs and wants of the individual, of the beneficiary. And our service coordinators are very flexible with how they are communicating and connecting with beneficiaries. So we have service coordinators who can go to a skilled nursing facility and meet with the beneficiary there. And we have service coordinators who can meet by telephone or remote meeting with individuals or meet out in public in a library or McDonald's even. So it's really dependent upon what's best for the beneficiary and in communication with the service coordinator. All right, so that is going into detail about the special needs trust. Let's talk about ABLE accounts. So ABLE accounts, which work really well with the special needs trust. ABLE stands for, and again, I'm throwing the disclaimer and caveat out there, which I am not an authority on ABLE accounts or an expert on it. I include at the end of this presentation a good resource for ABLE that I would highly recommend that you visit their websites and also view some of the webinars that are on their websites to learn more about what may be applicable to your specific situation. So ABLE stands for Achieving a Better Life Experience, and that was signed into law in 2014. It allows for there to be one account for an individual with disabilities for the purposes of saving funds while retaining public benefits. It can be an investment account, a savings account, or a checking account. A person can open an ABLE account at any age, but the onset of disability has to be prior to age 46. So that's one of kind of the special things about ABLE to keep in mind. And again, I talk a little bit about how is disability determined there. An ABLE account can only hold up to $100,000 in it that would not be considered a countable resource for SSI. All right. So if there's more in there in that ABLE account, but the person isn't on SSI, that's possible. But if a person may be receiving or could be eligible for SSI, then it's the first $100,000 that is not a countable resource. Right now, and this changes annually, so keep that in mind, up to $20,000 may be deposited into an ABLE account from different sources. So that's the total amount, which could come from different sources. So for example, and I'll mention this again, but a special needs trust, so plan, what we've done in the past where we have a beneficiary with a special needs trust, that beneficiary or their legal representative opens an ABLE account and we transfer funds over to the ABLE account. So from the special needs trust into the ABLE account. And that's one opportunity for the beneficiary, and it's very dependent on the beneficiary situation, whether or not that's a good fit for that to happen. So typically we are having a conversation about, is this an option? Is it a good option? What do we want to do here? But we certainly have done that. Again, the $20,000 is the total amount. So you could have $5,000 come from a special needs trust. A family member decides to put another $5,000 into the ABLE account as well. So other people can put money into the ABLE account. In addition to that, if the beneficiary, the individual with disabilities, is working, is earning, and has earnings from their employment, up to, it is right now, again, this changes annually, up to about $15,650 can also be added to the ABLE account from their income. There are there's some nuance to that. So it's something that you want to look into a little bit more and consult with somebody about regarding whether or not that would apply to your situation. But that is also some additional funds that would be possible on an annual basis. The account can generate income, and that's tax-free so long as the funds are utilized to pay for qualified disability expenses. So that's one of the differences. ABLE accounts have these QDEs, and some examples of that are food and rent, utilities, transportation, education, things like that. So they have very clearly defined things that the ABLE account funds can be utilized for, which will not impact public benefits. With regards to the special needs trust, it's not as clear and defined. So there are certain things from a trust that maybe we can't pay for, but if the funds are transferred from the trust over to an ABLE account, and it's okay for them to be paid from an ABLE account, that is one strategy that sometimes we employ, again, depending on the person and depending on the funds and the benefits. The entire situation is really comprehensively looked at. Another thing to keep in mind is that ABLE accounts do have a Medicaid payback requirement. All right, let's see, what else do I want to cover here? So one thing to be aware of is that there are different ABLE account plans per state. So in Massachusetts, Fidelity is the organization that handles the ABLE accounts here. However, there are ABLE account plans or institutions, financial institutions in other states that are also able to function here in Massachusetts. So it is, again, that resource page I provide. You can go there, and if you put in your state, I believe, you can then find out which ABLE account plan or organization would fit best with the state that your beneficiary may be living in. Or maybe you just prefer that particular plan and you can still utilize it in the state where the beneficiary is living. If an individual with disabilities is under age 18 and can't open and manage the ABLE account themselves, then the account can be opened by certain people in an order of priority. So for example, an individual selected by the eligible individual, an agent under a power of attorney, a legal guardian or conservator, spouse, parent, sibling, grandparent, or a representative payee. So you really want to think about what is your current situation, who has the ability to open this ABLE account. Again, if the beneficiary, that person who's going to be utilizing the funds in the ABLE account would be is under age 18. All right, and let's see here. How are we doing? Okay, so here's a quick comparison. Special needs trusts, there's no age restriction. There's flexibility in funding, so there's no limit annually or over the lifetime. There's only a Medicaid payback clause for first party trusts. And we are assisting with minimizing jeopardizing public benefits, and multiple trusts are possible. ABLE accounts, there are restrictions in age and the amount in funding annually and over lifetime. There's a Medicaid payback clause, or Medicaid payback is required for ABLE accounts, and there's one account permitted. All right, here's what I mentioned. A special needs trust can transfer funds to an ABLE account, but an ABLE account cannot transfer funds to a special needs trust. So that is something that you also need to keep in mind. Here's the resource page, and we're done. I know we only have 3 minutes, but let's see what we can do, and I'm happy to stick around a little bit longer if people still have time.
Thanks, Abigail.
Yeah.
So lots of information for families. So
Yes.
Couple of questions coming in from people. I'll just get right to the
Sure.
questions that I'm seeing. Someone asked, does the plan special needs trusts have Medicaid paybacks? So I think they may be talking about the pooled trusts.
Yeah. So our first party special needs pooled trusts with us at Plan do have a Medicaid payback clause. If it's a third party special needs pooled trust with Plan, there is no Medicaid payback clause.
Okay, so plan does first and third party.
You got it.
Okay. Someone else has 2 questions from the same person. First, are disbursements from an ABLE account executed through a debit card or formal withdrawal? I know actually just personally in Massachusetts, there is not a debit card as an option. I don't know if you have a different I just know personally because we have an ABLE account for my daughter. Unfortunately,
Perfect.
yeah, Fidelity does not offer that. They offer like a bank transfer you can do through the online account. Some other state accounts do offer the debit cards. Abigail, I don't know if you know specifically some other states plans people have used to have access to a debit card.
I do not. No,
Okay.
fortunately. Yeah, no, that's great. Thank you, Carrie. I appreciate your input on that. Great.
Yeah, and there is in our resource guide, there is a resource that lists out comparing each of the state's plans and what they
Fantastic.
have as far as, who manages the plan, if they offer, debit card, that kind of thing. So we do have that resource in our resource guide.
Mm-hmm.
And then someone else was asking what kind of management fees are involved for plan
Sure.
when they manage the plan.
That's a great question. So it may have changed since we just had our fiscal year just started, but as far as I'm aware, we have a 2% annual fee for our trustee services. That includes the service coordinator, things like that, on an amount up to $1 million, and there's no additional percentage over that for providing our trustee services. And then there's a 0.75 percentage annual fee on the entire amount that is being managed for our investment arm. So you're looking at a 2.75% fee essentially.
Each year.
Yeah, annually.
Okay.
Yeah, annually on the amount. Yeah, and there is an enrollment fee for the processing of the application, and it depends on what type of trust you're creating, and then also who's actually completing the documentation regarding those fees. It ranges from I think 500 up to 700, 750. When we are looking at other fees, we also have to do those annual tax returns. So typically that is around $300 to $400 for us to prepare that for each trust account. And then there is also closing fees. I think that's around $500 at this point. So if a trust is going to close because there's insufficient funds or the beneficiary has died, then there is an administrative fee for dealing with that paperwork as well.
Okay. Brittany Corman, I see you have your hand raised. You want to ask a question?
Yeah, sorry, I was trying to write it and it's just easier
That's
to
okay.
talk.
Sometimes it's easier to just
So I work for DDS and we were kind of always under the assumption that the special needs trusts needed to be irrevocable.
They are.
So, but I thought irrevocable meant like it would go back to the state, but you said the first party trusts don't have to go back, or can you explain that? I'm sorry, I'm a
Yeah.
little confused.
So an irrevocable trust means it can't be revoked. It can't be amended or changed. That's what irrevocable means. A first party special needs trust, whether it's pooled or the D4A, that has to have a Medicaid payback clause in it. A third party special needs trust, whether it's a standalone or a pooled trust, does not have to have a Medicaid payback clause in it, meaning the funds don't have to go back to the state in that way.
Okay, thank you.
You're welcome.
And I'll just ask too, because I feel like the Medicaid payback is kind of a big question mark for a lot of people. How is that calculated? So it's the full amount that Medicaid or Medicare has paid for health services for that individual over the course of their entire life?
Yeah, so it's typically Medicaid, once they are notified, and it's Medicaid, once they're notified that a person passes away, then they're going to assemble a document and information that says this is how much is owed, and we receive basically that letter saying this is what you need to pay us up to the extent that you can with the funds that are remaining in the trust. It's my understanding that it depends on the person's situation, but if somebody has been on Medicaid for a significant amount of time, it would apply for their entire lifetime, but I'm not positive about that. I can double check.
Okay. And I was just curious if family had any input on that amount, like if they thought the amount was completely incorrect, like
right.
Is there...
Yeah. I mean, there are ways that you can, so there are ways, and this is where you would want to have an attorney involved to best advise you. But you can actually, so in my previous life, I did some of this, which is where you can request, Medicaid will send you, for example, if somebody had covered or paid for costs for a skilled nursing facility for somebody while they were alive and the person dies, they will send you essentially like a summary of what the expenses were. And you can then go back to them and say, I would really like to have a more detailed report for you to then review. And then if you have any questions about that, you can reach out to a person with the estate recovery unit and have a conversation about that. In my previous life, I did some of that, and I always had a wonderful interaction with the estate recovery unit case specialists and figuring some of that out. It's typically not at the discretion of the family necessarily. So they're not directing payment or anything like that to reimburse Medicaid.
Right. But just if the family had
If there is
questions
a
about.
question,
Yeah.
that's one of the things that you can do to learn more information to determine, was it a legitimate expense for this beneficiary that now needs to be paid off? Or is this something that we need to have a conversation about and maybe it wasn't?
Someone else was asking about college funds. So asking if you set up a college fund at an early age for your child, should that be used to set up an ABLE account? So I'm not sure if they mean
Like a
if
$529.
they don't go to college, can you turn that into
Yeah.
an ABLE account?
Yeah. So yeah, again, I'm not an expert on this, but from what I understand, you can contribute from a 529 qualified tuition plan to an ABLE account. But I think you have to be careful about how much you contribute to the ABLE account from that 529 plan on an annual basis, right?
Okay.
So this is when I say I defer to the experts on this, and that would include looking at those websites that I mentioned in my resource page.
Great. And do some people use can you use an ABLE account to pay for college? So if they didn't set up a 529, if they set up an ABLE
Yeah.
account early on and the child does end up going to college, can you use that money for college?
So that's a good question. I think that it depends on if it falls under the appropriate category of a qualified disability expense. So that would probably require a little bit more research about that. But I did see that it generally ABLE account funds can be utilized for educational purposes.
Great. A couple more questions, if you don't mind sticking around a couple more minutes.
Sure. Happy to.
Can the plan special needs trust or ABLE account be used to purchase a house or pay rent? I believe that is a qualified expense, typically.
Yes.
Correct.
Yes. So we at this time plan does not serve as trustee of any trusts that own or manage real estate. So typically we do not serve as trustee of trusts with real estate in them. That's a special needs trust. There are other professional trustees who are out there that do. So if that's one of the things that's important to you, then I think some more investigation about if there's a financial institution or an attorney who might be a good fit as a professional trustee because they do manage or administer trusts with real estate. That's something to keep in mind. And that's something that's important to you. So that answers question number one. Question number two was in connection with rent. So it's my understanding that ABLE accounts you can pay rent from. Yeah, and they will not impact somebody who's getting SSI, for example. That can be where we as a trust have to be really careful about if somebody, depending on the type of benefits a person is receiving, whether or not we can pay rent for that person.
Okay. And then Lydia asked, do disbursements from third-party special needs trusts for supplemental expenses, in other words, not housing, count as income for Section 8 subsidized housing?
Good question. I think that I probably want to learn a little bit more about that situation before saying yes or no. So I don't think I know the answer to that. I can double check, but I would think in general, you probably could, but it's going to depend on what language is in you're talking about like a standalone trust, right? That's what the question asked.
Third-party special needs trust.
Just in general, a third-party special needs trust.
Standalone.
Yeah, so I think
if it's standalone, it's going to depend on the terms of the trust as well. So if there's direction in the trust that says, I want you to pay for this thing, then that's going to have a fair bit of influence on how we as trustee, where we put our discretion on what's getting paid for and not from the funds of the trust. Does that make sense?
Yes, there's a lot of new rules with HOTMA, and that's where this question is coming from.
Big time. And some of those, so HOTMA continues to be pushed off, right? So we have now been in a place where I think for at least 2 years, they keep on saying, just kidding, we're not instituting this quite yet. So I think at this point we're at 2027, like January of 2027, when it's actually going to be implemented. So I wouldn't be surprised if we continue to see this pushed off again, quite frankly. Yeah. And each housing authority has very specific rules. So that is when, and I know an attorney who is very knowledgeable in this area. So if you have a specific question, just let me know and I can refer you to that attorney regarding HOTMA in connection with a third-party standalone, and she can provide you with some great guidance there.
Thank you.
Yeah, absolutely.
A couple more questions. Can the ABLE account representative be different from the SSA rep payee? For example,
Yes.
Can the residential program be the rep payee for their SSI, but ABLE account rep payee be a family member?
Yeah. So if you look at some of the websites, again, there is a list. It's essentially a priority list of who can apply for and manage an ABLE account for a beneficiary who can't do it themselves. So there's an order of priority, essentially. So it can be different people with that in mind.
Okay. Let me see. Think that, someone asked if you can use a preloaded card such as a True Link with plan trusts as you can with a standalone special needs trust.
Great question. So we do utilize TrueLink. Again, it's very dependent on the beneficiary and their situation. But we do have pool trusts, beneficiaries with pool trusts and standalone trusts where they have a TrueLink card on their person or actually in the office to help facilitate purchasing items for that beneficiary. So it could be that we're assisting with purchasing food regularly or clothing or sometimes one-off items like collectibles or again that mattress. And so utilizing the TrueLink card is helpful in that way. And depending on the beneficiary, we can also give them, again, have the TrueLink card on their person and they can go make those purchases themselves.
Great. One more, and then we probably have to wrap things up here.
Sure.
Is there an annual regular accounting of the ABLE account disbursements to make sure they're qualified expenses? So is there any kind of tax form you need to submit or like annual report or anything like that?
I do not know the answer to that. Again, not the expert or authority. So I would probably be double checking with the websites that I provided about that. My guess is there is, especially if the account is an investment account and it's generating income. You're probably looking at some sort of income, receiving some sort of form in order to provide that for your personal income tax return annually. As to whether there is some sort of double check as to making sure that you are doing your qualified, every disbursement is a qualified disability expense, I do not know that answer.
I will just say personally, there's not a check like for you to receive the money, so you can submit for money from the ABLE account at any time. The advice that I've heard is to just hold on to receipts in case anything does come up.
Yeah.
So you can document that it was a qualified expense. But I don't believe there's no check before you submit for the money for reimbursement. So afterwards, I don't know if eventually someone will ask for that information down the road, but
yeah. So essentially there could be an audit in the future and to hold on to things, but
correct. Yeah.
You don't need a permission to utilize the funds. You just need to make sure that you're meeting those qualifications. And what are the penalties if all of a sudden you don't? I assume it would be that there could be concerns about now could those funds be considered accountable resource, depending again on the type of benefits you're on.
Yeah. And one thing I'll just mention, just again from personal experience, that I think a lot of people don't think about is parents that set up an ABLE account for their child before their child is an adult. Parents can also use that money to pay for things like summer camp or,
Mhm.
equipment if there's some kind of medical equipment or something the child needs at home. So, it can be seen kind of as an investment account for expenses for your child too. So if you put in money annually to pay for their summer camp, that's investment money. That's, making money while you're saving it. So that's
Yeah.
something that I think a lot of parents are thinking about it as future expenses, which it should be a long-term savings account, but it can also be for expenses when they're a child as well.
That's awesome. Thank you, Carrie. I appreciate I appreciate your additional
Because we
comments,
we do
especially
we
from
do that
personal.
as well. Yeah, we put in able account money, monthly, and then we use that to pay for summer camp. So
Yeah,
things like that with our
perfect.
daughter. So
Yeah, it gives you an opportunity to think creatively, right? And tailor things to your particular situation, which
yeah,
is wonderful. There's a lot of flexibility there.
yeah. All right. Well, I know we've gone about 15 minutes over, but this is obviously a very detailed topic, so there's always a lot of questions. But I'll turn it back over to Matt to wrap us up here.
Awesome. Thank you, Carrie. And Abigail, thank you so much for joining us today. We really appreciate your insights and
Absolutely.
yeah, a lot of really great questions as well.
Yes.
So
Great.
thank you everyone for joining today. If you haven't done so already, we'd love to get your feedback on how the session went today, so we can improve our network. And please share if there's any additional topics that you'd like to hear in the future. We'll be sending out the feedback survey in our follow-up email as well, along with that resource guide, the slides from today, the link to the recording, and our event guide. And if you have any additional questions, feel free to reach out to us at Community Resource Center at ne-arc.org. Awesome. Thanks, everyone. We hope you have a great week.